Community property. Community property is a system for or of marital property that's used in 10 states. Now, historically, we've had 8 community property states: Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington. And then the last several decades or so, 2 other states have passed laws that are pretty much like the community property system for marital property. And those 2 states are Wisconsin and then Alaska. But these other states, these original 8 states, are historically community property because this is part of our legal heritage that these states received or carried over from Spanish and Mexican settlement and colonization and rule. And as you can see on this map, that those 8 states are all located on the west and southwest portion of the United States. So as a result, in our community property system, wherever it is, and I'm going to be speaking specifically of Texas, but as a general rule, community property leaves us with 3 marital estates: the wife's separate property, the husband's separate property, and their community. And so as a result, spouses each have a 1/2 interest in any property that is acquired during marriage, and that's essentially what the community property is. Separate property. Separate property is going to be that property that is owned by the spouses prior to marriage. And it's also going to include property acquired during marriage by a spouse by either a gift, a devise, and of course a devise is going to be a gift in a will. If someone has willed something to someone, that property, that devise, is going to be a separate property. And then descent. And descent is referring to those situations where someone inherits property because they are an heir. If you're really going to be a purist about it, when you talk about an heir, you're talking about someone who takes property without there being a will. And we use the word, if you're going to be a purist, use the word inherit. An heir inherits because there is no will. So any property in that situation, any of these 3 situations, will be separate property of that spouse if that occurs during marriage. And of course, whatever they own prior to marriage. Now, separate property in Texas would also include a recovery for personal injuries that they had received, because that injury is personal to themselves. That maiming, that scarring, that disability. However, an exception to that is going to be lost wages. If the spouse has paid lost wages in that personal injury claim, that portion which is lost wages is going to be community property, because if those wages were earned rather than awarded as compensation, well, that would be community property, as we're going to see in just a moment. Separate property can be also created out of the community estate by written agreement of the spouses. Now, separate property is only owned by one spouse. Now, you could have a piece of property that might be like as you're going to see here in a bit, a gift can only be separate property. If it's a gift to the 2 spouses, well, each spouse will have a 1/2 interest. So a spouse, whatever interest that is only owned by that one spouse. It may only be a 1/2 interest of the whole, but that 1/2 interest, it belongs only to that spouse. And then, of course, separate property must be awarded to that spouse in a divorce. That's why people fight so hard to claim something as their separate property, because that takes it off the table, away from the judge to be able to divide if the ruling of the court or the fact finder is that indeed it was separate property. But therefore, it cannot be divided. Then what's community property? Community property is property that's acquired during marriage, except by gift, devise, or descent. In other words, community property is going to be everything that's not separate. Simple. Now, what might not be so simple are the rules that we use to characterize the property as either being community or separate. And that's the word that we use, characterize or characterization of property. Is it community or is it separate property? Now, there is a presumption that property owned during marriage, at the time of the divorce or at the time of the death of one of the spouses, when the marriage is over, there's a presumption that all the property is community. So that means that if someone's claiming that a particular piece of property is actually separate, the burden is on that individual to establish the facts that that property is indeed separate property, not community. So we got that presumption of community. When separate property and community property are commingled, well, if you can't separate it out, it's going to be characterized as community. We have a rule of tracing. And what we do there is that we follow the property and the forms of the property that it is in, and to determine whether it is community or separate as the property changes form, as it changes value. Let's drop down here. Change in form of the property doesn't change characterization. If I've got money I got from my grandmother in a will, and then that's separate property. If I spend that money on a car, that's separate property. I get married, and then while I'm married, I sell the car and buy a boat with that money. That boat is going to be separate property as long as I can trace all those financial transactions. This inception of title is saying that we use the time of when someone becomes the owner, when they take title of property. That's the operative date for characterizing property as separate or community at that time. Were they married at that time or were they not married at that time? So that's what we're talking about, inception of title, looking at that date. Changes in the value doesn't change characterization. If I have a separate property farm or piece of real property, and then I get married, and then I later during my marriage sell it for twice the value of what it was that I received it at while I was single, that increase in value is still my separate property. Changes in value do not change characterization. As I said before, a gift cannot be community property just by the definition that we use of separate and community property. So if a gift is made to a husband and a wife, actually one half is his separate property and one half is going to be her separate property. Now, of course, written agreements between the parties during marriage and before marriage can actually change all of this. They can agree among themselves that separate property could, or rather community property could become the separate property of one of them under certain circumstances. Let's look at some examples of separate and community property. Over here, separate property. A gift to a spouse, separate property. Payment for personal injuries, separate property. Increase in the stock value of stock, where the stock was separate property, well, that increase in the value is going to still be separate property. Anything you inherit, including family heirlooms, separate property. Cash from the sale of separate property. If I have separate property and then I sell that separate property during marriage, that cash proceeds, that's going to be my separate property, as long as I do not commingle it with any other funds that may be held as community funds. Remember, there is that presumption that it's going to be community. So I've got the burden's on me to keep the proof that it's separate. What about community property? A paycheck of a spouse, community property. Retirement benefits earned during marriage, community property. interest income, even if that interest income on a certificate of deposit, if the certificate of deposit is separate property, the interest on that during marriage is going to be community property. And this might be one of the things that the parties could change by written agreement if they wanted to do that. Crops from separate land. If a spouse owns a farm and then the crops are harvested and then sold, well, the crops, the value of those crops are going to be community property, because that's almost kind of like the income off the CD. Payment for lost wages, I mentioned before, in a personal injury claim, the maiming, the disability and all, that might be separate, but the lost wages portion is going to be community. So what are the factors in dividing community property upon marriage? Because once again, only the community property can be divided, not the separate. Well, first of all, understand married couples are not entitled to a 50-50 split, an even division of the community property. The Texas Family Code requires the court to make a fair and just division. Well, and what is fair and what is just is going to depend on the circumstances and different factors. There are going to be many factors that have been used in the past and that can be used to justify what might be an unequal division of property. Most courts are generally going to strive to have close to an equal division. It's not going to vary too much of the time, but there are factors for a court to consider to make it unequal, such as, well, does one of the spouses have a greater need for future support? Was there fault by one spouse or the other in the breakup of the marriage, like a fault ground, like divorce, like adultery or cruelty, or abandonment, something like that? The court can take that into account. Disparity in the ages between the two. Wasting away the community property by one spouse can cause a court to give a greater division to the other spouse. There are going to be many other factors, and they're listed here in this case that I have cited here, the Murph case, Murph versus Murph, 615 Southwestern 2nd, 696. It's a Texas Supreme Court case, 1981, and this is an overview of community property.